No, in the meantime, there's no need, Millards, over this. Please don't continue and don't entertain this because I'm going to point out it's an abuse of process. Not 1 rupee has been paid and you are blocking. So my point is you can ask for damages. How can...
Section 37(3) was open.
Millards,
Because
may I
all
just
these months he
straight
did
away-
not challenge.
No,
All
but-
these months he did
but
not
please,
challenge.
can I just
Only
first of
after
all-
the Delhi High Court judgment
let
on the
me
basis
clear.
of that he's seeking to challenge.
let us
And
be
my
very
friends,
clear.
facts are completely wrong.
No.
Yes, my lords, the arbitral tribunal was
The
constituted.
emergency award.
Yes.
After that, has the arbitral tribunal been constituted?
Yes,
yes.
and it has continued the interim measure of the emergency award. It's
But why
continued.
did you not ask for modification of that award?
No, they
No,
have
it
not
is.
challenged
We
it.
will be obviously asking for it now. Yeah, we'll be going over there. We filed an application there.
In the meantime,
No, in the meantime, there's no need, Millards, over this. Please don't continue and don't entertain this because I'm going to point out it's an abuse of process. He presses this application before the Delhi High Court, even though the arbitral tribunal is fully constituted and has continued the order. I'll show that order.
My lords, two high
So
courts.
he
have-
takes a chance here.
Two high courts have, sorry.
irrespective of Section 9 application,
Yes.
the award is binding between the parties.
No, there's no
Award
problem on
is
that.
binding between the
Keep that aside. I'm only saying this SLP deserves to be dismissed. There are two concurrent findings. It's an international commercial arbitration. Both courts have... Sorry?
That finding requires to be looked into. Raffles,
What is to be looked into, Millards?
see, you are saying two concurrent findings.
No, I am just...
First, one finding is based on Raffles. Raffles is
On?
incorrectly, Raffles judgment of the Delhi High Court
Raffles
does not
judge-
apply.
But babe, keep raffles aside.
Yes, keep
There is-
Raffles aside. Now,
There's a time-bound program.
your client should undertake that you will abide by the emergency award. That's all.
No,
That's
that
all
is
right.
already there.
If that is already there, we will not entertain this.
Yes, please, it is already there.
But
It
we
is,
will record your submission.
yes, your lordship
Record
will
your
say,
submission.
so your lordship will record two things on my part.
Subject to the arbitral tribunal.
Yes.
Modifying the emergency award, parties will abide by the.
That's all we are
Millards,
asking.
may I,
That's all we are-
that's number one. And number two, your lordships will note that I have moved the arbitral tribunal for variation.
We are making it very clear.
Yes.
Subject to the modification, vacation by the arbitral tribunal, the parties agree to abide by the emergency award.
Because he's moved for vacation on the basis of these two impugned judgments.
Second thing you want to be recorded. Yes, what
Sorry?
do you want? What is the second thing you want to be recorded?
No, I want to just explain this. There is a solar power plant in Tamil Nadu and there's a solar power plant in Bihar. The deal was that on the basis of a valuation of 1st of January or January 2024, the value was fixed between the parties. Because the value was fixed as of January 2024, when they entered into an agreement in December 2024, there was a hard stop that this agreement has to be completed by the 30th of April 2025. Hard stop. Parties agreed mutually to extend it to 31st May 2025. 31st May 2025 came and went. The agreement, the conditions precedent could not be fulfilled. They have not parted with 1 rupee so far. Not 1 rupee has been paid. And you are blocking. So my point is you can ask for damages. How can... No, I am
You are
just...
so aggrieved.
Can I just...
Section 37(3) was open.
My lords,
Because
may I
all
just
these months he
straight
did
away-
not challenge.
No,
All
but-
these months he did not challenge.
Can I just-
Only
first of
after
all-
the Delhi High Court judgment
let
on the
me clear.
basis of that he's seeking
No,
to challenge.
let us be
And my
very
friends,
clear.
facts are completely wrong.
No.
My lords, the contract says to the contrary. Contract says they are obligated.
This is a party
They have
who
not
hasn't
taken steps
parted
they are
with a
obligated
rupee
to take.
And get... Yes.
We are not going into that.
Yes.
We are not going into that.
So I want to answer your question.
Otherwise, you fight it out before the tribunal.
But it's his section 9. That's why I'm saying this must be dismissed.
Correct.
He got an emergency award.
Correct.
He got it extended by the fully constituted arbitral tribunal, but he still wanted to press his section
I'll
9.
tell my lords what happened.
Sorry, now it's recurrently dismissed.
I'll
And
tell my
rightly
lords what
so.
happened.
Yeah, just a minute now.
What about the enforcement of an emergency award?
No, Lord,
Is Section 9
My lord,
depth of
yes.
jurisdiction?
My lords, may I
That's
just...
the only
may I
way we
just
can
indicate-
enforce it.
First and foremost, your lordship is asking me a question of fact. Does the emergency arbitral award continue today? My answer is yes, it continues today. So let's be clear on that. So even though the Delhi High Court has rejected interim the application, but you must note that I have moved there for dismissal.
What's the date?
Give me that procedural order 2. Come on, quick. Procedural order 2 now. Don't.
Well, after the emergency.
He's accepting the emergency award to be binding on
They, in the meantime,
Just go
entered
to
an
page-
LOI to transfer the shares.
Don't fight over.
Possibly you can't have any, both sides go to before the tribunal.
Where will arbitration be
Go
left,
straight
Bharat, if
away.
we don't
Just
honor
go to
Bharat's
one
emergency
page.
awards
One
after
page,
choosing the
please read
system?
one page. Please go to page 429 at 433. Just have a look at it. 429 at 433, it's annexure P30. Just look at it. When have you moved your application to the area?
2 weeks ago.
Yeah,
And it's
okay.
listed for hearing on.
Please just have a look at it. Yeah. Okay. Just. You-
And those, I've given a cross undertaking in damages before the tribunal,
Now,
which is
please,
accepted
your-
by them.
Your lordships have it. Yes, correct. I agree.
So section 9 is the only way to enforce,
Ma-
and they are opposing enforcement. Yes.
Either to appeal against the emergency award or to seek modification. He says he
Or-
has gone to the tribunal.
Yes, correct.
to seek-
Only
And the
after the
matter-
impugned,
the
only
matter-
after the impugned
please note,
judgment. Bharat, in the
matter is
meantime,
listed for variation on 5th June. Now, first I must answer your question. Please go to page 429 and please go directly to page 433. This is the arbitral award, this is the arbitral tribunal's procedural order, 18th December 2025. Now, I'm going to read page 433, clause 5. The prohibitory injunction granted by the emergency arbitrator in the emergency order granted on 27th August 2025 will continue in full force and effect as on an ad interim basis until further orders of this tribunal. So the tribunal has continued it. This is coming up on the 5th of June on my variation. So now
All
the,
parties will, that's exactly what trying to impress on you.
so I am agreeing. But it can't be that your
Just two
lordships
things.
interferes here. That's
just
my
two
only
things,
request.
Bharat.
Yeah, I'm grateful.
Bharat, the statement,
Time is for enforcement.
Maladza recording his statement that he will abide by Maladza the emergency arbitrator's award continued by the tribunal.
Symbol is not, no, we record his submission that he said that it's binding inter party till the variation takes.
Till
Well,
the
the
variation
only
is
ground-
heard and disposed of.
Maladza,
Absolutely.
I just want to point out one thing. The only ground on which they are seeking vacation before the tribunal today is the impugned judgment.
Not going to that.
Yes.
Only the
correct.
impugned, not on merits. In the meantime, he entered into an LOI with a third party.
Arbitral Tribunal's wisdom, whether the impugned judgment is even applicable to them.
Maladza, may only clarify, the tribunal has full powers, Maladza.
Absolutely, that's what Mr. Dewan.
And Maladza, I just want to point out on conduct one thing, Maladza. My friend makes a submission here, we will abide. But on 27 November 25, his client enters into an LOI to transfer the assets to a third party. While the injunction of the emergency arbitrator is in place.
Not going to please argue before the tribunal.
Because his statement may be recorded, Maladza.
You record the state. Mrs. Ram Devan and Senior
Listen.
representing this number one in KVL.
Yeah.
At the outset has raised an objection, the maintainability of this specially petition on the ground that the matter is now listed before the arbitral tribunal on 5th June 2026, where their application for variation in the award, interim award
Of the emergency order. Yeah.
of the emergency award is also under consideration. He submits that the question of execution of the emergency award will arise after their application for variation is decided by the tribunal. So, we therefore dispose of.
Does not deny that the emergency award is binding inter party.
Does not dispute the fact that the emergency award is otherwise binding on the parties,
Yes. And as on date is binding. Yes, absolutely.
Yes.
binding on the parties.
Yeah.
That's all.
But it's my contention is that it will be, obviously, as your lordships have recorded, liable to be now vacated.
In
Because he's seeking vacation only on ground of the impugned judgment,
I
no
will
other
seek on
ground.
every ground.
So,
matter we.
He's saying we elected.
yes,
The
rightfully so.
parties shall raise their respective contentions before the learned
Tribunal.
on the date fixed, and or otherwise.
Well, tribunal may decide without being influenced by the impugned
No,
judgment.
no,
first.
that is, we are definitely going
That
to
is
argue
party
on this
autonomy,
basis.
Malan.
He
This
can
is
argue what he
arbitration.
likes.
I'm so sorry.
You know, the learned judges who are sitting there in the tribunal, they know very well.
Yes, exactly.
First,
Faithful.
2 out of 3 are retired judges of this honorable court, Bullets.
Exactly, and Justice Raja is also.
And they have, Mr. Raja, Justice Raja is there.
Yes, sir. So
Now,
therefore we
they
are-
have continued the emergency award. In the meantime, they've entered into an agreement to transfer to a third party, and they are relying on this judgment to seek vacation.
Section 9
So speaking in a forked tongue, Bullets.
order, Mr. Sipal, is at its height of persuasive impact.
Bullets, two,
Not binding on.
yes, they deem it irrelevant based on raffles, on a wrong reading of ancestral model law, unfortunately.
Mr. Diwan does not support the order
Yes.
on lapse.
So today,
Not in
we have
this court.
today we have a cleavage of opinion, between Calcutta High Court and Bombay High Court versus Delhi High Court. Two high courts take the view, if there is a foreign emergency award, it should be given some weight.
Delivered by this court
Yes.
has clearly held that residual power is there under
Amazon.
9 and 17(2) for enforcement.
Amazon.
So we are not going into
That's
that.
for India seated, That's for India seated. This is foreign
Now
seated.
let the arbitral.
But the spirit is, that we are to abide. My lords are right.
Again, please read Amazon with the amendment in 2000.
My lords are right.
Then
My lords are right.
if 9 applies even to foreign seated, interpretation
lords are right.
will be the same.
Para 40 and 41 of Amazon.
They're not going into that because Mr. Diwan admits that does not dispute that the emergency award is binding. He's only said that let the matter be.
Subject to
But
variation
his
there.
client tells the tribunal, please rely on Section 9 judgment to vacate the emergency award. That's what his client tells the tribunal. That's the difficulty.
Decide on its own. Don't worry.
Was uninfluenced, therefore I was asking, if my lords can consider.
Can't say unit.
No, Bharat, there's two orders over here. He took a
Laws
chance.
of India. The subject contract is to be guided by laws of India.
Laws of India,
High Court.
but on interim relief, it's the law of the seat that governs. On interim relief, law of seat governs. They have conceded that before the tribunal. They also agree that Singapore law governs the interim relief, which the emergency arbitral tribunal considers. So even vacation will be governed by Singapore law on interim relief. That's why I'm saying Section 9 may not be relevant there.
So argue that before the.
Yeah, we'll argue that. Grateful.
Obliged.
दोस्तों सुप्रीम कोर्ट में दोनों पक्षों के वकीलों ने अपनी बात मजबूती से रखी है। चूंकि ये मामला अभी माननीय अदालत के सामने चल रहा है, इसलिए इस पर सुप्रीम कोर्ट का जो भी फैसला आएगा वो सर्वोपरि होगा। हमारा मकसद सिर्फ आप तक कोर्ट की इस जरूरी बहस की जानकारी पहुंचाना था। इस पूरी कानूनी बहस पर आपकी क्या राय है, नीचे कमेंट्स बॉक्स में सम्मानजनक शब्दों में जरूर बताएं। माननीय सुप्रीम कोर्ट की ऐसी ही और वीडियो देखने के लिए वीडियो को लाइक और अपने चैनल को सब्सक्राइब करना ना भूलिए। जय हिंद दोस्तों।